Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of Samfiru Tumarkin LLP and the Western Canada practice leader with respect to disability law. We also practice other insurance cases in terms of life insurance and critical illness denials, sometimes mortgage denials, which go hand in hand with life insurance or disability. Please send us your questions via social media outlets and I'll field them as best as I can within the 30 minutes that we've got. So, first things first, something that comes up often would be, what is an invisible illness? And if you find that you're unable to work as a result of an invisible illness, how to navigate the application system. So what is an invisible illness? It's also referred to as a subjective illness or a subjective condition, which means that it is something that somebody experiences, but you cannot necessarily see it objectively on a CT scan or an MRI scan, or you cannot see it in terms of blood tests, for example. So things like fibromyalgia, chronic fatigue syndrome, also known as myalgic encephalomyelitis, chronic pain, also psychiatric conditions like depression, anxiety, post-traumatic stress disorder, bipolar disorder, anxiety disorder, and other types of mental health illnesses. These cases are usually more difficult to navigate because the evidence that you submit in support of the claim has to be compelling and convincing to the extent that the insurer will accept that the person who's making the claim is unable to perform the duties of their occupation. When you have a disability claim, you're making the claim pursuant to a policy, which is a contract. You may have it through your employment, where as a benefit through the employment, you have coverage for disability benefits, or as a self-employed person, like a doctor or a lawyer or a psychologist or some other self-employed business person, you may have purchased a disability policy. All of these are contracts, and those contracts have rights, obligations, and definitions, terms, provisions. So the definition for total disability in a general sense would be, you have to submit evidence to the insurance company that due to an illness or an injury, you are unable to perform the essential duties of your regular occupation or your own occupation. That definition may change later on to any occupation, but for the moment, let's just focus on that. When you have an invisible illness, you have to show that because of that illness, you cannot perform the duties of your occupation. If you have, for example, major depression, you would be seen by your doctor, you would be seen potentially by a psychiatrist, potentially by a psychologist as well. When the evidence is submitted, when you submit what is called an attending physician statement completed by your physician, what you want to submit is something where the doctor details what your restrictions and limitations are. So the doctor is going to say that over time, the doctor has been in a position to provide an informed opinion because they've observed you, not just with respect to what you're saying, but with respect to what the doctor is observing in terms of body language, the way that you speak, whether you are cognitively functioning properly or whether there are any abnormalities, that you've got a lack of focus, a lack of concentration, etc. All of those things need to be detailed in the attending physician statement because it's all based on what you say, but also based on what your doctor observes. If your doctor supports that you cannot work, think about, have your doctor, if you don't have a referral yet, have your doctor refer you to a psychologist or to a psychiatrist, and they can also weigh in on what their observations are and why they say that you are unable to work. A diagnosis is important, but the most important thing with any disability claim is evidence to support functional impairment. Why can you not function in the workplace? What are your restrictions? What are your limitations? Obviously, this doesn't just pertain to mental health illnesses, it also pertains to something like fibromyalgia, chronic pain. If you're taking medications to treat these conditions, how do those medications impact your ability to function, both physically and cognitively? Some medications make people very drowsy. Some medications make people have lack of motivation, brain fog, etc., which in itself may be a condition, part of the condition itself. So all of these things need to be detailed. Make sure that your doctor refers you to a specialist if it is one of these conditions, so that the insurance company can understand that this condition is being further investigated and further treatment is also being explored. You want to put forth the best possible evidence that you can at that initial application to avoid your claim being denied. Insurance companies often do deny cases when they say, well, there is no objective evidence to support this. Objective evidence can also come from the person itself in terms of what the doctor observes. So make sure that your doctor completes that form and identify what your complaints are, but also what the objective observations were that the doctor made of you during all the visits that you had. And if the doctor supported that you go off work, have the doctor comment on that and why it is that they did that. You may also want to identify what your occupational duties are. This is what it normally would look like. You would identify what your duties are, then what your diagnosis is or diagnoses are, speak about what the restrictions and limitations are, and then at the end conclude why, because of these restrictions and limitations, you are unable to perform the essential duties of that occupation. If your claim is denied, which hopefully doesn't happen, but if it were to happen, please reach out to our firm because we field questions from people all over the country, other than in Quebec and the territories, with respect to disability claims that have been denied. And what we do at our end is we offer a free consultation to review the denial letter, the policy, the medical evidence, etc. And so we can provide to you what your options are, and you can make an informed decision. As you can see on the screen, you can go to disabilityrights.ca for further information. So we've got a question from Bronto, and it says, what happens if you become pregnant while on LTD? Does this change your eligibility or cause your insurer to cancel your payment? So if you were to become pregnant on LTD, I suppose the question really is, what happens if you are pregnant and you were to then have the baby? Are you eligible for other benefits? Because most policies do provide, and it depends on the language of each policy. Let's just be clear about this, that benefits may be suspended for a period of time while you receive mat leave benefits through the government, so EI benefits for that period of time. So if that happens, then your benefits may not be terminated, but it just must be suspended for a period of time that you are receiving mat leave. There's, of course, a completely different situation that if you were to become pregnant, and I've seen this many times before, and there is a complication with the pregnancy, and this may be while the person is working, they then go off work as a result of that early on. So LTD benefits, remember, it's because of an illness or a condition. So if there's a complication, that's a health issue. So you should be eligible for benefits for that period of time until the baby is born. And then if you're eligible for other benefits, depending on the policy, it may deem to be suspended for that period of time. And then be careful here. If that does happen, you want to make sure that you continue to see your doctor on a regular basis in terms of your disability and report to the doctor your ongoing restrictions and limitations. I've seen many cases where the person did go off on claim, then there was a pregnancy, there was a baby born, and during that period of time, there were no visits to the doctor, for whatever reason it may be, that the person had to focus on the baby, which is completely understandable. But remember, the policy requires you to be under the regular care of a physician. So make sure that you continue to do that. And once the EI benefits end, if your position is that you're still disabled, inform the insurance company, because they're going to be looking at the clinical records for that entire period. And hopefully they continue your claim. If denied, contact us. Lindy says, what happens if your diagnosis changes while on LTD? Does receiving a terminal diagnosis while receiving LTD change things? Do you have to let the insurer know about this change? When you have a disability claim, it is based on your functional impairment, regardless of the condition. So if you have gone off work because of depression, and the insurance company has approved your claim and is paying to you benefits, but later on then you may have found that you have a diagnosis of cancer, do you have to inform the insurance company of that? I would say yes, because that actually supports your claim. And I'm sorry if this is the situation, Lynn. If that happens, the insurance company will also have to look at the restrictions and limitations resulting from the new diagnoses or the new diagnoses. So you as a person will be considered globally as to how you are functionally impaired because of all the diagnoses. So if you are on claim because of one condition and others arise later on, those conditions also become relevant as to whether the insurance company will continue to approve your claim. So yes, I would say you should inform the insurance company. You're very welcome to reach out to us as well, Lynn, if you want to have a further discussion about this, because I'm happy to have a chat with you to see exactly what the situation is. There's also, and as again, we go on the screen, you can see disabilityrights.ca, where you can get further information. There's also a duty on a person to provide evidence and information to the insurance company. So you have to cooperate. So if they do have what is called telephone interviews with you, or functional telephone interviews with you, and they ask you questions pertaining to your condition and doctor's visits, etc., you have to be honest. So if that does happen and you've got new doctors because you've now receiving care from other specialists, I think it makes sense to inform the insurance company of that, because it ultimately will support your claim. It won't detract from it. Then there's a question on YouTube from Grace. What is the statute of limitations for addiction/treatment costs and disability coverage? So I'm not quite sure what that question refers to. So statute of limitations really refers to a timeline within which you can pursue a legal claim. If an insurance company denies your claim, there's something called a limitation period that runs. And the limitation period runs from that date, or maybe from the date that your claim had been paid last. It depends, and this is important to understand, it depends on the statute of limitations, or the Limitation Act, or the Insurance Act of your specific province. In BC, for example, the limitation period would start to run from the date that you knew or ought to have known of the claim being denied, so the date of the denial, or if your claim had been paid, from the date that the next payment would have been made. It usually is 2 years. So the statute of limitations that is being referred to here usually is 2 years. When it speaks about addiction/treatment costs and disability coverage, the addiction/treatment costs, I'm not sure what that refers to, because under a disability claim, the insurance company's obligation to you is to pay to you disability benefits. If they deny your claim, the cause of action arises to take legal action, if that is what you choose to do. There's a timeline within which you must do so. That is called the limitation period, which is the limitation period to file a legal claim. If you have a question pertaining to that, because I don't know in which province you would be, you're welcome to reach out to us and we can advise you once we have more information. But generally, it is 2 years from the date that you knew or ought to have known of the denial. Even if you have missed the limitation period, still reach out to us, because there are certain instances where you still can pursue a legal claim. You have to understand how these things work. So I would advise that you go to a lawyer who actually deals with disability claims, understands the workings of the Limitation Act and the Insurance Act, as opposed to somebody who just dabbles in this area. Then there is a question from Anib on YouTube. What is the difference between assessment and survey in the 2-year mark of disability? The insurance company asked a third party to do a survey instead of an assessment. Is there a difference? I actually don't know what the term survey refers to. I've not really seen that in disability claims. An assessment, so this is how it would work. Let's say you have what is called a own occupation period that ends, and then the disability definition changes to any occupation. What that means is the insurance company is, after 2 years, if it is a 2-year own occupation period, is going to assess whether you are unable to perform the duties of any other occupation for which you have the transferable skills by means of your education, your training, and your experience, which you could medically perform, and that would pay to you a certain amount of money. If in the policy there is a percentage, it would be, say, 60% of your pre-disability income. If there is no percentage, then it would be something you could perform that would pay to you roughly the same as your LTD benefit amount. The assessment that is done is at the insurance company's end. They're going to be looking at the medical evidence. If they feel that there is something that you may do because you may have some function, they may have a transferable skills analysis done by a third party, or in-house sometimes, where that person who does that analysis maybe the assessment that we're speaking of, would be done on the basis of what is your education, your training, your experience, what are the restrictions and limitations, and based on all of those, is there a job available in the labor market that you could perform? If so, and that would pay to you a certain amount of money, if so, you may be facing a denial. An assessment may be where the insurance company sends you to one of their doctors or a third-party doctor which they pay for, or a third-party functional capacity evaluation to see what your restrictions and limitations are and whether, because of those, are you able to work in another occupation. Surveys are not done. I think what we're referring to here may be something different. So it's either transferable skills analysis, or they have one of their in-house doctors do an assessment based on a clinical review, or they have you seen and assessed by a third-party doctor. And based on that, they may then do a transferable skills analysis. The assessment has to support, if they want to deny your claim, that you are able to work in another occupation. Now, lots of people get denied at this juncture, but it doesn't mean that you have to accept the insurance company's decision at this stage, because they often don't get it right, meaning that they may not have considered all your restrictions and limitations when they considered whether you're able to work in another occupation. Or you may have had very limited experience working in an office setting 10 years or 20 years ago, been working in a physical capacity, and now the insurance company says, well, we think you can go work in an office setting based on your experience from way back when. Of course, it has to be realistic. So we get involved in cases very, very often when a claim is denied at the change of definition phase. So if that is what's happening in your situation, please reach out to us and we'll consider with you what your options are, explain them to you, and you can make an informed decision. Do not simply accept when an insurance company denies your claim that their position is correct, because this is what they do all the time. We, at our end, will evaluate things and explain to you whether you have options. And for the most part, people do have options. You can then just simply decide what option makes sense to you. Lindy says, thank you, I appreciate the information. How would any critical illness coverage interact or overlap with LTD, or are they treated separately? It's a very good question. So remember, and this is very important to understand, with critical illness, there are very strict timelines within which to apply. So how do they overlap? Do critical illness benefits get deducted from LTD benefits? They should not be deducted. Critical illness is a one-time payment that you are eligible for if you meet the definition of a specific critical illness, as that definition is defined in the critical illness policy. So if you have a diagnosis, and it sounds like there is a terminal diagnosis, it very likely will be covered in the critical illness policy. So what you want to do is you want to go to the treating doctor immediately, have the doctor complete the paperwork and submit the claim for critical illness to the insurance company. Many people have had their critical illness claims approved and also their LTD claims approved, or critical illness denied for whatever reason, and still receiving LTD. You can apply for both. You may be eligible for both. The one provides you income protection. In other words, it's a income replacement benefit, which is LTD. It gets paid to you as long as you remain totally disabled within the meaning of the policy. Critical illness, you do not have to prove that you're disabled. You simply have to prove that you have been diagnosed with a certain critical illness, if that illness is included in a critical illness policy. For example, cancer. Not all cancers are covered by a critical illness coverage policy, but if it is terminal, I would be very surprised if it is not included. It should be included. There may be other reasons why a critical illness claim may be denied. For example, you may have had symptoms or signs of the illness just before you got the coverage, or for some other reason. So do submit the claim. If it is denied, by all means, again, you can reach out to me. And you know what, Lynn, if you have any other questions outside of this forum, you're welcome to reach out to our firm and we can discuss with you or respond to your questions if you've got other questions. I know this must be very stressful, so we're happy to have a chat with you. Again, go to disabilityrights.ca for more information. Lee, do you have doctors who can help clients when they don't have a family doctor? Unfortunately, we don't. But I could say this, when we do get involved with respect to a claim that has been denied, when we pursue a legal claim, we may, like insurance companies send their insureds, meaning you, when you're making a claim, to a third-party doctor for an assessment, we may do the same at our end. So if the insurance company has sent you for an assessment with a third-party doctor, for example, a psychiatrist, and you've got a mental health illness, and that psychiatrist gives an opinion and disagrees that you're disabled, and they deny you on that basis. At our end, if we get retained and we pursue a legal claim, we can do the same. We can either request an opinion from your treating doctor, or if you do not have a treating psychiatrist, we can have you sent, depending on the circumstances of each claim, to a psychiatrist as well, a third-party one, to provide an independent medical examination opinion. But unfortunately, no, we do not have doctors who we can send you to in terms of a treating capacity. You may want to try in your province, contact the governing body for the doctors, see whether any doctors are accepting patients, reach out to the walk-in clinics, and also see whether there is any online availability with respect to seeing doctors through MediHelp or MediHealth, telehealth, however they're referred to in your province. Stephen B says, we've been dealing with a not-so-kind adjuster with our insurer, saying the doctor is not correct, trying to force a different treatment provider. What is the best way to deal with this? Firstly, I think you should contact us and provide further information so we can consider what exactly the situation is. If the insurance adjuster is being completely unreasonable, you may want to speak to their manager. You want to make sure that everything is put in writing. You want to make sure that you see your doctor on a very regular basis. Advise the doctor that they are questioning your doctor's opinion. Make sure that your doctor then provides support if your doctor agrees with your position and provides the rationale for their position or their opinion or their decisions. If the doctor feels that you should be referred to a specialist, have the doctor do so. Make sure that the doctor records everything that is discussed in terms of your restrictions and limitations, and underscores thereby, if the doctor were to provide an opinion, that it is an informed opinion. If the adjuster is disagreeing with your doctor's position, have the adjuster, and insist on this, have the adjuster put in writing why they are questioning what your doctor is saying, submit that to your doctor, and then have your doctor provide a written opinion as to why the adjuster is out to lunch. Because the adjuster is not a doctor, right? But it may be that the adjuster is acting on evidence, or an opinion rather, from what is being said in-house. So what often happens is they may have had your doctor complete a form, or they may have received your doctor's clinical records, then refer those clinical records to and they do have doctors in-house, to an in-house doctor to provide a records review and to respond to certain questions, where that doctor may be questioning your doctor's treatment or your doctor's opinion. If that is the case, have them commit that to writing, submit it to your doctor, and have your doctor then rebut what they're saying and provide the rationale as to why the doctor is following the path that they are following with respect to the treatment and the opinion that is being rendered. Ultimately, if that didn't answer your question, you're welcome to contact us and we can discuss it with you further. Kyle Merriman says, hi, I'm currently on EI sickness benefits and have a class action against the insurance company through my work. Am I able to go back to work if my doc says I should? Okay. You're receiving EI sickness benefits at this time, meaning that your doctor is probably supporting that you cannot work. You're also involved in a class action against the insurance company. You're asking, can you go back to work if your doctor says you should? I would think so, because if you want to receive benefits from an insurance company, then you have to prove that you're unable to work. We always say when we speak to clients, follow your doctor's advice. That would be the most reasonable thing to do, because your doctor is in the best position to provide an opinion. Therefore, if your doctor suggests that you go to work solely based on that, are you able to work? I think so. With respect to the class action thing, I don't have enough information on that, but I don't see, based on just thinking about this as we speak, would that prevent you from returning to work? I don't see so. And I don't see why not, because if you're able to work, that's what you should be doing. If you've got further questions, again, you can reach out to us beyond this session. Stephen says, thanks. One more question. Are we allowed to record the phone conversations with the adjuster? They often record things. I've had many people tell me that they record things. You may want to tell the insurance adjuster, I'm going to be recording this conversation, like they do with you. But make notes as well, and insist if you're not comfortable having those discussions, and if the doctor says it's actually aggravating the disability, it's creating further stress and anxiety. I've seen doctors put in writing why a person should not be communicating via the phone, but everything should be done in writing. I'm not saying that's the situation here. That may just aggravate things, but you may want to consider that as well. But I would be upfront with them. Kathy McInnes Contagianis, I hope I pronounced that correctly, says, can you tell me anything about what to expect if insurance company asks for early mediation with LTD? Okay, so I'm assuming that if you're saying the insurance company is asking for early mediation, that you have a lawyer. So it's difficult for me to give opinions on that. But what I will say is, if an insurance company is asking for early mediation, that's not necessarily uncommon. Remember, you may not know this, and anybody who's listening, when you have a lawyer representing you with respect to a denied disability claim, they're doing so because a legal claim was filed. That legal claim gives you leverage to negotiate with the insurance company. So even if they denied your claim, they may still want to negotiate with you because the legal claim gives you leverage. When you do an appeal, you have no leverage. There's nothing that you've got on the insurance company. It's simply going to them and say, please, will you change your position? This is the same insurer that denied you that is now doing an appeal. Whereas if you file a legal claim, the people who were handling the claim before no longer are involved. It now gets passed on to the legal department where they have litigation consultants. Yes, you're dealing with another lawyer, but through your own lawyer. You don't deal with the insurance company any longer. All communications go through your lawyer. And because of the legal claim, there's no risk to you and to the insurer that if this ends up in front of a third-party decision maker, then it may go either way. So that gives you leverage to negotiate with the insurer, and they know that, and they want to as well. So when insurance companies requesting early mediation is because they're wanting to negotiate with you. And the only way to get to that point is by pursuing a legal claim. Now, what to expect with respect to early mediation? Have a discussion with your lawyer about that, because I think you do have one. But the focus of mediation, I will say this, is to resolve a claim. It's not to prejudice the process or to sabotage the process. It is to negotiate a resolution of that legal claim. Question from Kyle on YouTube. I was in a car accident with a delivery driver. I was ruled not at fault, but apparently the delivery driver is not insured. Do I need to file a claim against the company instead? So unfortunately, I cannot respond to this question because we're dealing with a disability Q&A. If you were to be disabled as a result of the car accident, in other words, you're employed, you have disability insurance through your employer, and now because of that, the car accident, you are unable to work, submit your claim to the insurance company, and hopefully they approve it. If they deny it, again, you're welcome to reach out to us. You'll see on the screen soon. You can go to disabilityrights.ca for more information. Just to be clear about this, when a claim is denied, you have options. And you want to know what those options are. And you want to navigate how the process. What is the best way to navigate the process once a claim is denied? What we do, as I've said before, we offer free consultations where we review the denial letter, we review the policy if you have it available, we review the medical records and opinions if you have those available, and we discuss with you what your personal circumstances are to explain them to you once we have all of that information so we can provide to you an informed opinion as to what your options are. Be it an appeal or be it litigation, you ultimately make the decision. As I said, with respect to appeals, ultimately these things are adjudicated by the insurance companies themselves, whereas a legal claim provides leverage for you to pursue a legal claim and to get some compensation from the insurance company. The benefit with those is we represent you. You don't have to deal with the insurance company anymore. But it doesn't mean you have to go down that process. Once we've discussed it with you, you can make an informed decision. Also important to remember, as I said before, there are certain timelines in place. So if a claim is denied, reach out to us so we can discuss that with you. There generally is a 2-year timeline within which you can file a legal claim, and you want to know when that timeline begins to run and what may impact your decision moving forward as to the outcomes of these different processes. We do this, as I said, on a free basis and review all the documents with you. So you're very welcome, Stephen, and you're very welcome, Kathy. I hope the information was helpful. If you've got further questions, you're welcome to reach out to us. And with all of that being said, thank you so much. This was a good session, lots of questions coming through. Let me tell you when the next session will be. The next live stream will be an employment law Q&A with my partner, Samfiru. That is set for Wednesday, which is tomorrow, July the 24th, which is at 1 p.m. Eastern Standard Time, which would be 1 p.m. Eastern Standard Time, which I would say is probably 10 a.m. Pacific Standard Time and 11 a.m. Mountain Time. Don't quote me on that. Anyway, have a great day and look forward to seeing everybody or fielding more questions next time with our disability Q&A. Have a good day.